This is an ancillary and an appeal in the matter of Lenovo Group Ltd and others, and LM Ericsson and another.
Mr. Douglas.
Good morning, my lords and my lady. I appear for the appellant Lenovo with my learned friends Mr. Segan, KC, and Ms. Pickard, and my learned friends Mr. Pickford, KC, Mr. Brubeck, and Mr. Eustace appear for the respondents Ericsson. Before I start with the substance of the appeal, there are two procedural matters. First, there was a request which was sent up for a Pro Tem 3122 order covering confidential information that's in the bundles and may be discussed. An order was agreed by the parties and submitted and was recently updated prior to the hearing.
We have seen that, and we're content to make an order in the revised form.
Thank you very much. The second is our application to adduce the 13th statement of Ms. Dagg. I understand from my learned friend that that is not opposed for the purposes it is put forward for, which is updating the court, particularly for the re-exercise of the discretion if that arises, and the court is with me on that.
And that's the position, Mr. Pickard.
That's correct, my lord.
We'll make that order as well.
So, my lords, my lady, turning therefore to the substance of the appeal, you will have seen that this is Lenovo's appeal against the dismissal of its application for a short-term licence to hold the ring pending resolution of this dispute. The order we're requesting is in the same terms as were ordered in Panasonic and is in Core Tab 17. And in effect, it declares appropriate licence terms to hold the ring, such terms to be subject for later adjustment by the court. And it declares that a willing licensor and willing licensee would enter into those terms, and that to refuse to do so would be a breach of the Falk commitment. Now, for today, I have divided my submissions into 5 parts. The first is a brief background to the approach to FRAN cases and how this appeal arises. Second is the background to the present dispute and the subject matter of the various different foreign actions. Third is the approach to short-term licenses arising from the judgments of this court in Panasonic and Alcatel, and why we say those principles apply to the present case. Fourth, why we say, with respect to the learned judge erred below. And fifth, why this court should re-exercise the discretion if it is with us, and what we would be asking the court now to do if it is. And that is where Ms. Dagg's 13th statement is relevant. I plan to leave further responses to the respondent's notice, further to what we have already said in our supplemental skeleton, until reply. So starting with the approach to FRAN and a brief background, the judge introduced the essence of the FRAN commitment in the judgment at paragraphs 14 to 20, and neither side appeared to quarrel with it. And he explains that the wellspring of an implementer's contractual right to an offer of a FRAN licence is clause 6.1 of the ETSI IPR policy, which is governed by French law. This requires the SEP holder to undertake to grant a licence on FRAN terms and creates a French law contract between the SEP holder and ETSI for the benefit of third-party implementers. And the judge explained that FRAN is not merely an end result, but a process of negotiation designed to avoid both hold up by SEP owners and hold out by implementers. At paragraph 22, the judge recorded the agreement between the parties that Article 1104 of the French Civil Code imposes requirements that the contract must be negotiated, formed and performed in good faith, as was set out by this court in paragraph 48 of Panasonic. And the judge also recognised correctly, we say at paragraph 20, that the ETSI IPR policy creates a contractual modification to the usual rights of patentees. That flows from what was said in the Supreme Court in Unwired Planet. And SEP owners therefore do not have an unfettered right to seek injunctive relief. That was discussed by this court in Interdigital and Lenovo. And at this court, Lord Justice Arnold explained at paragraph 23 that this modification means that although SEP owners continue to be permitted to request and to obtain injunctions against implementers, they can only do so to the extent that this is consistent with their undertakings to ETSI. Now, Unwired Planet concerned enforcement by a SEP owner and confirmed that English courts have jurisdiction to settle global license terms and declare them as terms that a willing licensor and willing licensee would enter into as the price to operate the UK SEPs. And later cases have made clear that implementers too can come to court and request a global FRAND determination. And the court in IDG explained that this has led to a shift, perhaps, in attitudes discussed in Panasonic. Implementers have become more enthusiastic about court-determined global licenses, and perhaps SEP owners, in certain instances, less so. And as the court recognised in Panasonic, SEP owners have become more aggressive in pursuit of parallel proceedings and seeking injunctions in numerous jurisdictions, indeed the very thing one might say that Unwired Planet was intended to avoid. And it is in this context, in Panasonic, that the court at paragraphs 14 to 16 discussed interim or short-term licenses arising to seek to regulate the position pending a FRAND determination. And short-term licenses engage two important principles, which were set out in Panasonic and discussed by the judge. I will come back to Panasonic in due course, but for this introduction, it's important, we say, to have these 2 points of principle well in mind, and they are set out in the judgment in the core bundle tab 1. At page 11, bundle page 11. And here in paragraph 37, the judge quotes from Lord Justice Arnold's judgment in Panasonic, and you see at the bottom of the quotation of paragraph 79 of Panasonic that, in effect, the SEP regime is a liability regime in which the SEP holder's remedy is a financial one. The only role for an injunction in this regime is to enforce the SEP holder's entitlement to that financial remedy. And then in 80, the second point is an implementer is entitled to a license from the first day it implements the standard, provided it is willing to take a license on FRAND terms. And then at the bottom, the implementer is entitled to a license which is continuous and not subject to interruption by injunctions obtained by the SEP holder. And the judge at 39 then, we say rightly, explained at the bottom, 5 lines up, that he agreed that these statements of principle concern the FRAND commitment and obligations imposed by ETSI IPR. They are not qualified as applying only to situations where both a SEP holder and an implementer have given undertakings to the English court to be bound by its determination of FRAND license. That is a distinction that my learned friend relies on in this case, and I will come to in due course. But for present, we point out that we agree with what the judge, with respect, with what the judge says there in paragraph 39. Now, my lords and my lady, if I now turn to my second part of my submissions, which is the background to the current dispute and the actions that have been commenced. And it's important to understand in my submission what they are and what they entail. The parties both own portfolios of SEPs and both need a license from each other and both accept that. Lenovo needs a license for its phones, laptops and tablets, and Ericsson for its cellular infrastructure business. Now, Ericsson's portfolio of SEPs is well known and is larger than Lenovo's, and it's a very well-known SEP licensing company. But that does not mean that Lenovo's portfolio is not substantial. It is, particularly in the field of 5G, and the evidence that was recorded by the judge in the jurisdiction judgment at 51 is that it holds about 60% as many 5G patents as Ericsson. Now, on the 11th of October 2023, Ericsson made its offer, which features a lot in this matter, and the terms are set out by the judge. And again, if you would just take the judgment again at page 19 of the bundle. paragraph 82, the judge records the offer. It's not written in terms of, it wasn't made in terms of a lump sum to be paid, but you will see that at little Roman 3, in relation to 4G smartphones and tablets, it was requiring a fixed sum of 65 cents per unit, but no royalty would be due for 4G equipment that is already the subject to a previous license, which I'll come to in a moment. And at 5, it appears, he says it's common ground that the proposal for 5G would cost around $1.50 per 5G device. And at paragraph 88, the judge also records a later offer by Lenovo in August 2024, where again a $1.50 rate was put forward for 5G. So unlike in some other cases, the dispute in the present case is not so much about the per unit rates, but what they are said to cover. One part of the dispute is what Ericsson should pay for the cross-license to Lenovo's portfolio. The other part, a very significant part of this dispute, is what is already covered by a 2011 license granted by Ericsson to Motorola, which could potentially last until 2035. The reason that is relevant is Lenovo bought Motorola in 2014, and Lenovo says that the 2011 license covers all the Motorola phones and removes the claim for royalties on those phones potentially back to 2011. By contrast, Ericsson says that only specific phones developed as of a certain date and their descendant models are covered. And it's an extremely substantial dispute and accounts for the largest part of the difference between the parties. In paragraph 46 of Ms. Dagg's 9th statement, she explained it's potentially worth hundreds of millions of dollars, and that has not been disputed. And you can get a pictorial idea of its significance if you would kindly go briefly to the supplemental bundle in tab 11. Page 136. This is Ms. Dagg's 10th statement, and it's a pie chart prepared for the ITC proceedings, which I will come to. But the red portion of each pie chart represents the proportion of 4G and 5G patents that Lenovo say are already licensed under the previous agreement. And you see that both for 4G on the left and 5G on the right, and one can see how significant that is for 4G. The dollar figures that are included in there, as she explains here in the statement, have now been updated, but it illustrates how much of the dispute is bound up with the proper construction of that license. Now, while I go to that, it's important to understand that that is a dispute that can only be resolved in the UK. And the reason for that is the 2011 license had an exclusive jurisdiction clause in favour of England and Wales, the courts in England and Wales, and English law. Now, as I've shown you, the judge recorded at paragraph 82 that Ericsson's October offer carved out 4G equipment that is subject to that license. But one has to be aware of what that might mean, and one sees that from Mr. Foster's evidence for Ericsson, and that again is in the supplemental bundle, tab 19. On page 208, this is his 5th statement. And at paragraph 68 of that statement, he, 3 lines up from the bottom, says that according to the express terms of Ericsson's offer, if Lenovo proves that a 4G handset was covered by the 2011 license, then Lenovo would owe no royalties on that device. Now, we say that's important because that proof can only be done in the UK and could change what Lenovo ultimately has to pay by hundreds of millions of dollars. So this is not a case where the UK has been selected without real connection to the UK or anything like that. And we say the centre of gravity of the legal dispute is very much in this jurisdiction. Which then means I need to turn to what actions have been commenced both here and in other jurisdictions. In the UK, there are 3 actions commenced by Lenovo, 2 of which really matter for today. The first is the current action, which was commenced by Lenovo to set a global FRAND rate for a cross-license, including assertion of one of its UK SEPs. The second is Lenovo's action to determine the amounts due under the 2011 licence, and a preliminary issue trial on interpretation of that licence was heard by Mr. Justice Mead in January, and judgment is awaited. Ericsson had attempted to put that trial off.
I've seen reference to that in the skeleton arguments. Can you just tell us what the preliminary issue that Mr. Justice Mead was considering was?
My understanding, my lord, is that it's looking at the interpretation of that agreement as to whether it is right that Lenovo is correct, that the agreement covers all Motorola devices going back to, I think the date is 2011, or alternatively, whether in fact Ericsson is correct, and one has to be more granular as to the devices that are actually covered.
So in what sense is that a preliminary issue? Because that seems to be, so far as I've understood so far, and maybe just my ignorance, the main issue, if not the only issue in those proceedings.
My lord is right in this sense. It is, I don't like to use the word cut through, but if Lenovo is correct, then that removes all that past tail from payment. My lord is right that if Lenovo is incorrect and Ericsson is correct, then it means that there is likely to have to be an inquiry as to which of the devices actually are generationally covered, because it was, I believe, their case is that it's devices from a certain date, which I will get for you, my lord, and descendant models. It's specific phones developed as of 4th of January 2011 and their descendant models. And so then that requires, which Mr. Justice Mead has not done at the preliminary issue trial, to look into which of those phones were developed as of 4th of January 2011 and which are their descendant models. And so if what's behind my lord's question, will the preliminary issue determine things finally? It may, which is why it was heard, but it may not.
So if it's determined in your favour, that's basically it. If it's determined against you, then there's a factual inquiry.
That's my understanding. And we accept, to the extent, I think my learned friend makes a point on it, we accept that that factual inquiry, if it has to arise, will not take place before the FRAND trial in April, for obvious reasons, and will have to be after that.
Well, the Ericsson skeleton says there's no trial date at all yet, is that correct?
I believe that is correct. Well, the third action, as I say, does not probably matter for today's purposes. It was an action on another SEP by Lenovo, and it was the subject of an interim injunction application attempting to get interim injunctive relief to prevent Ericsson's actions said to cause irreparable harm, and that application did not succeed. It came before Mrs. Justice Bacon and then up to this court on the basis that damages were an adequate remedy within the UK and the irreparable harm referred to was abroad. And I'll briefly show you that as it arises in one area of today, but for most of today I don't think that action need trouble us. Turning to the foreign actions, these feature very heavily in my learned friend skeleton, as the reason why relief sought in this appeal is not appropriate. And there are 4 material proceedings commenced by Ericsson, proceedings in the Eastern District of North Carolina, EDNC, proceedings at the International Trade Commission, or ITC, and infringement proceedings in Brazil and Colombia. Now, paragraph 8 of their skeleton, my learned friends rely in particular on the proceedings in the EDNC and ITC in respect of their points on comity. As regards the EDNC, at paragraph 43, my learned friend says that this will determine FRAND as well as the substantive dispute between the parties, and say that there, at paragraph 4, that there's no good reason to afford English proceedings primacy or preference. And as regards the ITC, similar points are made. At paragraph 7, he says that the ITC is the proper organ of US government to adjudicate on SEP disputes. And at paragraph 43, he says the ITC will determine the substantive dispute. And at 53, he says it's using the same test as would be applied here in the English courts. In light of those submissions, it's obviously important to understand what is being determined in those proceedings, particularly the EDNC and ITC. Our overall submission is that contrary to above, what he says, in fact, this court is the only court globally that is certainly going to undertake a FRAND rate determination for a cross-license, is certainly the only court globally that can determine the principal dispute between the parties of how much is payable in light of the 2011 license. And their actions in the ITC, Brazil and Colombia are seeking to put pressure to obtain higher rates than this court may award. But looking at what is actually an issue and turning first to the EDNC, Ericsson have said this is their preferred forum for rate setting, and that was their basis of a jurisdictional challenge at the outset of these proceedings, which failed. And Ericsson has said it will comply with the result of the EDNC. Now, the first problem with the EDNC action in that sense is that it might not actually determine a FRAND rate at all. And that was the finding of the judge at paragraph 55 of the jurisdiction judgment. And the judge also explained that the reasons for that fall at Ericsson's door. And it's discussed in the jurisdiction judgment, and you will find that in the JA bundles at tab 15. I don't know if my lords and lady have 2 or 1 JA bundle, but one. In that case, that's fine, tab 15. At page 395 of the bundle. And here, this is Mr. Justice Richards at the jurisdiction stage. He starts discussing evidence of Justice Gajasa, and about 4 lines down from the top, he says, more significant is Justice Gajasa's conclusion that there have been other cases such as Microsoft and Motorola, in which US district courts interpreted obligations owed by patentees, that to the ITU and IEEE, as requiring only that initial offers be made in good faith. Accordingly, in the Motorola case, he explains that. The judge then says that he considers there's potential read across between the Motorola case and what's happening in the EDNC proceedings because of the prayer for relief that Ericsson is requesting. And their primary request is to adjudge and declare that Ericsson has complied with its FRAND commitments and all applicable laws. And of course, if Microsoft and Motorola was followed, the answer to that could be that they have, because their initial offer was made in good faith, which is not a FRAND determination in the sense of this court. They only ask for a FRAND determination conditionally, and you see that in little l, if Ericsson's offer is determined not to be consistent with FRAND commitments, only then adjudge and declare a FRAND rate for a global cross license between the 2 parties. And the judge then goes on to explain that there had been discussion about whether Ericsson would clarify what's being requested, and sort the issue out. And he sets out in the middle of 64 a proposal, which he says, does not dispose of the point. And then at 65, he says, given Justice Gajarsa's evidence and the way in which the request is framed, it appears conceptually possible that the EDNC could decide Ericsson complied with FRAND, even though its offer was not FRAND in its own terms. Correspondence between the parties that I was shown indicates that Ericsson is not willing to rephrase paragraph 1 of the prayer for relief, so that it requests simply that the EDNC adjudge and declare FRAND rate for a global cross license. If the prayer had been worded in this way, I consider it would have been dealt with the concern. Since Ericsson is not prepared to make the amendment, I conclude the concern remains, and that formed the basis of his finding, which I referred to earlier, which is a page before, paragraph 55, little 2, that there's a possibility the EDNC will not ultimately determine a FRAND rate for a global cross license. Now, we say that's extremely telling, that despite saying this is the preferred forum for rate setting, Ericsson has declined to amend the request simply to ask for rate setting. And we say a fair inference is Ericsson does not want FRAND rate to be determined by actually any court. But there's also more difficulty with the EDNC, which is discussed by the judge here, which is the time it is likely to take to resolve the issue. And the judge noted in paragraph 69 of this same judgment on page 396, that at least when he was hearing this back in April 2024, it wasn't clear to him that a trial in the EDSC would be likely before late 2026. And one of the problems is the docket there, and he explains that in the middle of that paragraph, that the Judge Boyle, who's docketed to the case, the median length of time from filing and obtaining a trial is for that particular judge 45 months. And there's also real difficulties because they are going through a very busy period of claims relating to a water contamination at a military base, which the judge explains has been described as one of the largest mass litigations in history. Now, nonetheless, Lenovo has said it would abide by any rate set in the EDNC, provided Ericsson agrees to stop seeking and enforcing injunctions in the interim. And that is recorded in the judgment under appeal at paragraph 57. Now, we say the caveat is important and fair, and we stand by it. Ericsson says it wishes a rate determined in a court whose docket is currently quite overloaded and proceedings are moving slowly. And because of the way they have framed the relief, and they will not change that, it's not even certain a rate will arise. So although we are content if they wish to accept the result of the EDNC proceedings, it cannot be that in the interim, until at the earliest late 2026, we are to be subjected to ongoing injunctions from Ericsson. And Ericsson doesn't need those injunctions, we say, but plainly it doesn't suit Ericsson, and they have refused that proposal. Now, turning to the ITC, as my lords and lady may know, is not a court, but is part of the executive arm of the US government, tasked with addressing claims by importers of important products which infringe US rights, in this case patent rights. And the judge correctly records at paragraph 74 that the ITC does not undertake FRAND rate setting determinations. It's already different from here. FRAND does arise with a SEP because if a US patent is found, or US SEP is found to be infringed, the ITC will have regard to US public interest factors, including unfair trade practices, before granting an exclusion order preventing importation of the products to the United States. Now, the judge noted in paragraph 70 that nobody has identified a case where the ITC has declined to grant an exclusion order because of a failure to comply with FRAND, but nonetheless it does have a duty to consider unfair trade practices. Now, the fact that the ITC is not a rate-setting body and the approach of the ITC is also recognised by Ericsson in their evidence, and in light of what's been said in my learned friend's skeleton, it is worth briefly looking at what they said in Mr. Foster's fourth statement in Supplemental Bundle, tab 18. Page 183. And at paragraph 23, Mr. Foster for Ericsson explains that the ITC will consider whether Ericsson comply with its FRAND obligations and will factor into assessment of whether an exclusion order would harm the public interest, but it does not require rate setting and is not engaged in such an exercise in prior investigations. They consider whether Ericsson comply with FRAND obligations and will factor into assessment of whether an exclusion order should harm the public interest. In past cases, this has focused on negotiation conduct and whether the patentee was willing to offer a licence and negotiate it in good faith. So a similar thing we saw from the district court, and not FRAND rate setting at all. Now, as part of the assessment, Ericsson's October offer, which I showed you the summary of in the judgment, has been reviewed and in the context of public interest factors. And one can get a flavour of the approach, all we have at the moment, and is relied on by my learned friend, and was heavily influenced the judge, was a brief that was submitted by the US Office of Unfair Import Investigations, or UWI, I think it can be shortened to, that has been submitted in the ITC proceedings. Now, the role of the UWI is not disputed. It's explained by the judge at paragraph 72 of the judgment. It's an independent party and body. It's independent of the ITC, and it takes the role of, if you like, an independent third party representing the public interests and making submissions. But it is not the ITC, and it's not bound to follow its submissions. So one has to take them with that in mind. And my learned friend in his pre-reading asked the court to look at the UWI, and I will do the same, which is in Supplemental Bundle, tab 20, starting at page 220. You see from this that it is a brief following the hearing, and it has been put in on behalf of the UWI. And one can get a flavour of the approach from page 220, bundle page 222. Where in the second paragraph, the UWI say that their argument is that the weight of the evidence shows that Ericsson has complied with the FRAND commitment by negotiating in good faith. This is in the context of whether, if infringed, an exclusion order should be made. And they quote down below various US case law, including the importance at the bottom, that whether exclusionary relief would have adverse effects on the statutory public interest factor. If you go to page 225, you see they refer to Microsoft and Motorola in the middle paragraph. Considering good faith, initial offers do not have to be on FRAND terms so long as a FRAND license eventually issues. And they taught at the bottom the approach to looking at whether negotiations have been done in good faith. Now, at paragraph 237, this brief does review the October 2023 offer, and in the submission of the UWI, it is within the FRAND range, and you see there just above the lower hole punch, it does not indicate bad faith. And they start with the 5G offer, and they go through, and we can pick up on page 239, the figure that we saw before, that actually we are coming around the figure you see in bold there, which I think was in the judgment, of how much per device. And their argument is that that is within a FRAND range, and you see that at the top of page 240. They say that the amount there per unit is within a FRAND range based on unpacking. But as I have explained, my lords and my lady, whilst many cases are about rates, this case is about more than that, and the driver of the dispute is about how much is paid under the 2011 licence and how much should be paid for the cross licence. Now for that, you do deal with that, and you see that at page 242, where they look at the cross licence component, but they say only that it's not so unreasonable as to indicate bad faith. So no question of valuation. There's a dispute between the parties as to whether it's a royalty-free exchange for HEVC patents or not. And here, all the Newey's put forward is, well, it's not so unreasonable as to indicate bad faith. In relation, if you turn over the page, we see they end up that actually Lenovo's positions might also be legitimate, but the fact that Ericsson holds the opposite view is not bad faith. So
Sorry, where are you?
Oh, sorry, page 243, between the two hole punches, just above the little heading Ericsson's 4G offer.
Yes.
So it's the end of the 5G part. So they only look at the cross-license element to say, well, both parties have their positions, but no bad faith. Then on the 4G offer, they look at the rate that we saw in the judgment of 65 cents per device. But over the page, they accept that that isn't the primary dispute, and you see that under the bit that's blacked out between the two hole punches. Lenovo's primary argument is the offer does not account for the 2011 license. But on that, you see again after the heading and by the lower hole punch, they were of the view that Ericsson's understanding of the 2011 license is not so unreasonable as to show their offer was in bad faith. Now, of course, it's not for them to determine what the construction of that contract actually is. That's for the English court. But their position is it's not so unreasonable to be bad faith. And they repeat that again on page 246. And you end up at 251, finally with a review of Lenovo's conduct. And at the bottom of page 251, they have the view that Lenovo is technically not an unwilling licensee because it's agreed to be bound by the UK rate setting, but their willingness appears to be qualified by terms set by its preferred forum, the UK, after all appeals have been exhausted. That's not correct. The Lenovo willingness has been very clear.
That's not correct, but the judge says that your client's position changed in that regard, and that was the original undertaking, but subsequently it was modified.
My lord, it's not correct. My lord's right, it's not correct by the time of the judgment. I'm not criticising the Newey. I'm saying it's not the position now, and the position now is that the undertaking is as perhaps has been done in other cases, which is that it is an undertaking to take the court-appointed licence also to be altered if necessary on appeal.
Yeah, so am I right in understanding that formally speaking, that the only undertaking which has actually been given by your clients is that which was given in October 2023, but subsequently you have offered a modified form of undertaking, but am I right in thinking it's not actually been embodied in any order yet?
I will check whether it's been embodied in an order. My lord may be right. if I may just well, my lord, there is a formal undertaking in our amended particulars of claim at paragraph 67, which is core bundle, page 150. Oh, sorry, core bundle tab 12.
Thank you. Right, okay, thank you.
And you see there, it will enter into the licence in the form determined to be frowned at trial, or to the extent any appeals, and finally determined on appeal. And that, my lord, is in our particulars of claim. Finally, on the Newey, one just sees at the end there what they were addressing, or what they know that the ITC will want to address on page 253 is whether imposing an exclusion order raises public interest concerns, and there they confirm their view and argument is that it would not, and you see that just under the heading 6. But standing back, we say that one can see from this that the ITC is not undertaking a frowned rate determination. Its task is different from the task being undertaken by this court. They're considering whether the US public interest factors negate an exclusion order. And they have reviewed, or may review, certainly they're being asked to review, Ericsson's October offer. But as we've seen, it's looking at rates, but not what the dispute here is really addressing, which is what is covered by the 2011 licence and what amounts are payable to the cross licence. And as my lords and lady will understand, there are also other issues for determination at the Frown trial, such as what should be payable, if anything, for inclusion of HEVC SEPs or NEPs, that's issues of scope that often arise at Frown trials, and other terms that the Mr. Justice Mead will be considering in April. None of that is to be determined at the ITC. And of course, the interpretation and what is covered by the 2011 licence cannot be determined anywhere else than here. Yet Ericsson are seeking an exclusion order before that dispute can be adjudicated in the UK. And the timings of the ITC proceedings before the judge were set out in Ms. Dagg's 7th statement and are not disputed. They are set to conclude on the 17th of April. And if an exclusion order is made, it will come into effect 60 days after that. So I think on 16th of June, depending on any presidential review in the interim, which is part of the procedure. Ms. Dagg has explained the effect of this in her 10th statement, and we quoted that in paragraph 30(3) of our skeleton argument. It is EEO, and so I can't read that out, but if my lords and lady would go to our skeleton argument in core bundle tab 4. Paragraph, page 69. And it is the part in blue, which I won't read out. What I can say, which is not in blue, is what we say before that, that it would be catastrophic for obvious reasons. Finally, my lords and lady, we have other actions. Now, Lenovo has itself commenced responsive actions, including at the UPC, but has always been clear that it will not seek to enforce any injunctions if Ericsson will do the same. And that is confirmed in paragraph 15 of Ms. Dagg's 4th statement and paragraph 22 of Ms. Dagg's 7th statement. Ericsson has not done that, and they instead have started and enforced injunctions in both Brazil and Colombia. Nobody suggests that these are FRAN determinations. They're not. They're patent enforcement actions in which Ericsson continues to try to obtain preliminary injunctive relief. And these jurisdictions have been chosen to inflict maximum pain and pressure. And it is worth seeing what other courts have said, earlier courts have said about their conduct in these actions. And you will find that in the JA bundle tab 16. Page 406, this I referred to earlier, was the judgment of Mrs. Justice Bacon in relation to the interim injunction, but I go to it today for what she says at page 9. Here at the end, in paragraph 20, she explains that Brazil and Colombia account for around 25% of Lenovo's smartphone revenues in 2023, Brazil being the vast majority. And although Lenovo is continuing to make sales in Brazil, basically there is a monetary value attached to that, it is not seriously disputed that injunctions obtained are causing and will cause very significant disruption to Lenovo's business in markets that are very important in commercial terms. And over the page, she says it was implicit in Ericsson's evidence that Ericsson has pursued the proceedings in Brazil and Colombia as a means of exerting commercial pressure on Lenovo to reach agreement with it on the terms of a global cross-license. And the one they want is in terms of their offer. So that was what the judge recorded from the evidence there. Mr. Justice Richards also commented on Ericsson's strategy when he was case managing the FRAN trial in these proceedings, and you find that in tab 18 of the same bundle, page 500. There was a dispute here about the case management in that Lenovo suggested FRAN going first, and Ericsson resisted that, even though both sides accept they need a license, and Ericsson was wanting a technical trials first. That was refused. And paragraph 42, the judge explained that there's a fundamental reason, a more fundamental reason why the FRAN proceeding should go first. It's abundantly clear that Lenovo and Ericsson need a FRAN global cross-license. He says at 43, Ericsson repeatedly disavows any attention to seek to exert pressure on Lenovo to exact super FRAN rates by obtaining injunctions in important markets, such as Brazil and Colombia, yet continues to devote efforts to secure the benefit of those injunctions. There is a suggestion of hold-up in those actions, as well as trying to keep Lenovo out of the market in important jurisdictions. Ericsson's favoured venue for determining the FRAN cross-license, the EDNC, might end up not fixing the terms of a license at all, and even if it does, is likely to do so only in late 2026. It is also, in my submission, worth remembering what this court said when the appeal of the refusal of an interim injunction came before it, and for that, my lords and ladies will find it in tab 20, page 608. And the court may wish just to read paragraph 58 of my Lord Justice Arnold's judgment there. So, my lords and lady, we say that although the court there said an interim injunction application was not the right approach due to issues of American Sanamid and the like, there is potentially another approach, and that is why we are before you today. We say that the relief requested below and on this appeal is intended to regulate the position pending the Fran trial and final determination of the dispute. Which brings me then to the third part of my submissions, which is the approach to short-term licenses, why we say this case is appropriate based on particularly the leading authority in Panasonic and Xiaomi. Now, the facts of Panasonic and Xiaomi were that both parties had committed to take a global license settled by the English court, but nonetheless Panasonic sought to obtain injunctive relief from both German courts and I think also the UPC, the Unified Patents Court, in the interim before the Fran trial. Xiaomi requested a declaration in terms that we seek today, and that was ordered. Now, if one finds Panasonic in tab 21 of the bundle, and I've already shown you the passages quoted in the judgment in paragraphs 79 and 80, which I've already gone to, which explain the role of injunctive relief in a set case and the entitlement of implementers who commit to take a license to have a license uninterrupted by injunction. At paragraph 48 of this judgment, my Lord Justice Arnold sets out some key points in relation to the good faith requirement, and one sees those over the page set out as a quote, 134, 135 and 136, and there's no dispute that those apply today. There is a dispute about paragraph 49, whether or not there is a requirement in principle that can lead to a creation or modification of a party's rights, and that's a matter for the respondent's notice. We say it doesn't matter for today because we rely on what is said in paragraph 48, which is agreed. That'll be a matter for my learned friend. The ultimate conclusion on Panasonic's conduct and whether it was a breach of good faith is found in paragraph 86 on page 635, where the court determined the question as whether Panasonic is acting in good faith as required by clause 6.1 of the ETSI IPR policy. The fact that Panasonic may believe it is entitled to adopt this course does not compel the conclusion that it is acting in good faith, and it is said here, in my judgment, the conduct is indefensible. As discussed, FRAND is a process and not merely an endpoint. Panasonic is not complying with its obligation to negotiate a license in good faith and thereby to avoid hold-up, but aiming to coerce Xiaomi into accepting terms more favourable than the Patents Court would determine to be FRAND. As regards useful purpose and comity, it's worthwhile we're here just looking at those because they arise before you today. And there you will see in paragraph 90 on page 636, Panasonic had said that it might ignore the declaration. You see that in paragraph 89. And in paragraph 90, the court did not accept that and thought it would nonetheless serve a useful purpose in forcing Panasonic to reconsider its position. It would not force Panasonic to change its mind, but there's a realistic prospect that it will do so. And at the bottom, the court says that it hopes that Panasonic will see the error of its ways, but consider there is a real prospect of it doing so. And over the page at 95 to 7 in comity, the court disagreed with the premise that making the declarations is only to influence the outcome of German proceedings. It was not. And as the court then goes on to say, if the declaration did induce Panasonic to reconsider its position, it would promote comity because it would relieve the courts and the UPC of burdensome and wasteful litigation. And if they decided to ignore the declarations and pursue the foreign proceedings, then it's entirely up to those foreign proceedings to make their own assessment, including the conduct, and decide what to do. Finally, and it's relevant for today when we get to the judgment, at the bottom of paragraph 99, the court made clear that it is a FRAND licence that's being looked at, and you see that in the middle of paragraph 99. The question is what a willing licensor in the position of Panasonic would do. The court is just as capable of determining what terms of an interim licence are FRAND as what are final. And as counsel for Xiaomi accepted during the course of argument, it's open to the court to decide that neither side's proposal for interim licence is FRAND. But contrary to the view taken by the judge, it does not involve determining what terms for a final licence would be FRAND. And as my lords and lady will appreciate, the interim licence has a figure to be paid, but it also has an adjustment clause up or down once the determination is final. Now, the current case differs from Panasonic because, unlike in Panasonic, Ericsson has not undertaken to take a FRAND licence settled by this court. And that feature of the Panasonic case was recognised by the court in Panasonic.
It's not the only difference, because the other big difference is that in Panasonic it was the SEP owner who had first invoked the jurisdiction of the English courts to settle the global licence. So it was Panasonic coming to these courts saying, please determine what is FRAND on a global basis. That's point one. And then point two is the one you've mentioned, which is there was then the undertaking from Panasonic to abide by the result. So there are those two factual differences.
My lord is correct. I was going to come to the second one, but my lord is right to pull me up on that. And what I would say on the first, well, what we have here, of course, is Panasonic has invoked the jurisdiction of this court. Sorry, Ericsson has invoked the jurisdiction of this court in relation to a large body of the dispute in the exclusive jurisdiction clause in the licence.
Well, hold on a minute. It was your client that brought the proceedings, not Ericsson. I appreciate you say you were obliged to bring them
Indeed.
to this jurisdiction because of the exclusive jurisdiction clause, but nevertheless, it was you that brought the claim.
That is right. I accept that, my lord. But it's we have brought the claim in light of an exclusive jurisdiction clause for England and Wales agreed upon by Ericsson. Moreover, of course, we are suing on a UK SEP, and so that brings in also the cross-licence element, which I have explained are the two important prongs. And Ericsson accepts it must take a licence. The judge recorded that that was admitted by the parties. Both sides accept they must take a licence. So it's not a case where they don't accept they need a licence. So, which I think is paragraph 2 of the judgment. So, my Lord Justice Arnold is absolutely correct, but we say here we have an agreement to have what is actually the biggest driver in this dispute determined in the United Kingdom, and we have a UK SEP sued on by my clients as part of its portfolio for a cross-licence where Ericsson accepts it must take a licence. That again engages the UK. Now, if we go to the passages that relate to this in the judgment, and that's, we can start, I think we can take it up at paragraph 45. Which is on page 625. Here, the court refers to the amount of time and effort that has been expended, but says that a key question is what the point of this is when it is certain that in relatively near future, the parties will enter into a global licence on terms determined by the English Patent Court, with the effect that all Xiaomi's acts will retrospectively licensed. And this goes to the point, I think, that in this case, Panasonic had undertaken to take a licence, and in this case, Ericsson has not. However, in this case, it is certain that the terms of the
Sorry, I think I'm in the wrong place. Which
paragraph
paragraph should I be in?
paragraph 45, page 625, Murray.
He's in Panasonic.
Oh, I'm sorry.
So, sorry, I've
It's
got my.
in JA tab 21.
Oh, I see. Yes, I see.
I'm sorry.
I was in Panasonic, but I'd moved on.
No, my fault.
Yes.
And so one key question, I was just submitting, reading really, the key question that the court said was that there is certainty, and that in that proceedings arose because Panasonic had given an undertaking to the court.
Yes.
In present proceedings, Ericsson have not done that. However, there is certainty that the Fran trial will be proceeding. There is also certainty of a result on the 2011 licensing issue, and certainty that the parties will be bound by that. And we say, as I'll come to, that simply not giving an undertaking can't be the be all and end all of interim license relief, and I'll explain that in a moment. The court here came back to the importance of that in that case slightly later on in the judgment at paragraph 81 on page 634. And there, at paragraph 81, the court explains that the key factor in the present case was it was certain that the parties will enter into a global license on terms determined to be frowned by the Patents Court. It then goes on to explain at the bottom of 81, there's no suggestion that Xiaomi will be unable to pay, and it follows it's certain that Panasonic will soon receive its frowned remuneration for exploitation of its portfolio. And then at 83, the point I believe that my Lord Justice Arnold was just putting to me in the middle there, that Panasonic has itself invoked the jurisdiction of the English courts to determine what is frowned on a global basis, and has undertaken to accept the determination of the Patents Court, and therefore inconsistent for Panasonic to force Xiaomi to agree to terms more favourable than English courts would order by pursuing proceedings elsewhere. Now, we say the judge rightly held that short-term licence declaratory relief is not limited only to cases where both parties have undertaken to take an English determined licence, and is not limited only to cases that have been commenced by the SEP owner. We know from the previous cases that implementers have a right also to bring cases, and where they do, it is likely to be the case that it's not the SEP owner that has invoked the jurisdiction of the English court. What has happened is it's a different SEP owner in this case. The SEP owner now is Lenovo, who has invoked the jurisdiction of the English court. And Lenovo is a SEP owner, as I say, of a substantial portfolio, and importantly, Ericsson accepts a cross-license is necessary. But also in this case, we have the added feature, which is both parties are bound to the UK because of an agreement that Ericsson signed, that the UK and the English courts have jurisdiction for what is actually the nub of the dispute. Now, we say it would create perverse incentives if one SEP owner a cross-license, all they have to do is to, if they want to sue for injunctions around the globe, even though the implementer has fully committed to take a Fran license, simply refuse to commit to the license here. It's actually an incentive to move further away from the obligations to Etsy, not towards them. And we say what actually matters in this type of relief, and plainly those were important facts in that case, and I don't shirk from that, they plainly are. But we say they do not define when the relief can be requested. We say that this relief requested by an implementer can only arise where an implementer has committed to take a Fran license on terms to be determined by the court.
So on your submission, that is the key factor.
No, and I was going to also then go on, it is a key factor in that without
Well,
commitment.
I mean, I take your point about the 2011 license, and obviously that is a factor in the overall equation. But in terms of the comparison with Panasonic, except there are two factual distinctions in that Ericsson has not brought a claim here for determination of RAND rates, nor has it undertaken to accept the English court's determination. But you say those two distinctions don't matter because the commonality lies in the fact that you have undertaken to take a license on the terms determined to be FRAND, and you say that means that Ericsson is guaranteed to get what is FRAND.
That is right. Ericsson is
You
guaranteed.
say that's sufficient.
Well, I also say in this case we have, I do also very firmly rely on the 2011 licence. Each case is on its facts. My overall submission is a relief such as this, like much holding the ring relief, is factually dependent. And one has to not say this is always, I think it's very dangerous in my submission for me or the court to say this is a set of facts that will always arise. But we say what's important here is that we have committed to take a FRAND licence and therefore they will obtain the money. Moreover, there is no other court where they will obtain finality on the money to be paid, because no other court can consider the 2011 licence. I have also shown you the difficulties with the other courts, both in the EDNC and the way it's been framed.
Yeah, I'll just ask you about that. I mean, you emphasise again the 2011 licence, and as I say, I understand that. But I think it leads to this question, which is to what extent the jurisdiction the court exercise in Panasonic would, based upon what at one point I characterised as safeguarding the integrity of the UK proceedings, and to what extent it's based upon a freestanding view of what the FRAND commitment entails.
When I also as a freestanding view, you mean an English court view? Or...
Yes, because I mean, one view, the reason why Panasonic was a clear case was because, as we've discussed, Panasonic had invoked jurisdiction. They had undertaken to accept the result, and yet they were trying to subvert that which they themselves had put in train by seeking injunctive relief elsewhere in the world. And that's why Lord Justice Phillips dissented, because he took an equally strong view that that was conduct to be condemned, but his view was that the proper remedy was an anti-suit injunction. But the point about that is that what it tells you is that it's about safeguarding the integrity of the UK proceedings, because that's the justification for an anti-suit injunction.
Well, here, in my submission, that's exactly what will be going on. Ericsson, has to be remembered, itself voluntarily gave the undertaking to Etsy for good reason. It benefits from that. It took on the obligations that Etsy requires. That includes not harassing, to use, or obtaining injunctive relief to prevent an uninterrupted view of a licence. That was all Ericsson's voluntary position. The integrity of these proceedings, I've shown you the evidence of Ms. Dagg. These are the only proceedings where a fair and proper resolution of the whole dispute can be undertaken, and yet the injunctive relief being sought is, in my submission, going to the integrity of these proceedings, because...
This reminds me of something that I should have asked you earlier. There was an application by your clients for an anti-suit injunction in EDNC, and the last I heard of was that it was turned down, but the CAFC allowed the appeal and remanded. So what's happened?
Nothing, in my understanding. This is something I don't want to impose on what Ms. Dagg said in her 13th statement based on what Ellen and Friend said, but I think it's fair to say nothing has happened.
Right, so that is still pending.
It's gone back, and I understand nothing has happened in these proceedings.
Right. Thank you.
And just picking up, you say this is the only court where everything can be sorted out. By the time you had an EDNC hearing at the end of next year, wouldn't the 2011 licence position be clear because of what had happened here?
Yes, the problem is whether we get to that. You'll have seen Ms. Dagg's, the part I made to read you, that if in the interim, in the injunctions have their are as effective as Ericsson hopes they will be,
You wouldn't.
we won't have the determination here.
Yes.
And that does not just impact on the FRAN determination in April, but it also is what may happen in the licence determination.
But that sort of has nothing to do with the 2011 licence, because that's not going to be determined immediately anyway.
Well, it does, in my submission, impact on the eventual determination of that, because my lord is right that if Mr. Justice Mead finds fully for us, then that determines that issue. We know where we stand. If he doesn't, then there requires a factual finding. That factual finding needs to be undertaken, and that potentially will not happen if, and you've seen what Ms. Dagg has said.
Yes.
I need to be slightly careful because of
Yes,
open court.
I follow.
So we do say it is to protect the integrity of these proceedings. And we do say that we, as an implementer, have a right, and it's the right approach in our submission to do so. We are a SEP owner in these proceedings and the cross-license. We are also bound by the 2011 licence. And we know that a FRAND rate and eventual amount to be paid will, with certainty, come out of these proceedings, incorporating all the issues between the parties, not just some of them. Now, hold the ring relief will not arise in every case, plainly. But here we say that we have committed to take the licence settled by the court. There's no uncertainty about Ericsson receiving money for the whole dispute. We've explained that Ericsson itself agreed to what's turned out to being the vast bulk of the dispute to be determined in the UK by the exclusive jurisdiction clause in favour of England and Wales. It's the court where the cross licence will be determined. And the response of Ericsson, we say, also is important in the factual matrix, where they have gone to a court, the EDNC, and refused to amend it in the way the judge said perhaps would have avoided uncertainty. They have refused to agree to a patent piece while the dispute is being determined. It's not a case where they've agreed to a patent piece somewhere else. They've said no patent piece. We say that is entirely contrary to the ETSI obligations, where an implementer and a cross-party to a cross-license says, we need to resolve this, we will resolve this quickly as we can in the UK, or if you want to go to the EDNC, we will accept that if there's patent peace, saying we will not agree patent peace and we will continue to pursue in the interim, we say engages relief such as this and ought to engage it as a clear breach of the ETSI obligation. And it raises the same question as one has and was asked by the court in Panasonic. Why is Ericsson pursuing injunctive relief and exclusion orders in circumstances such as this? They cannot be needed to force an implementer to accept a court-determined licence, because Lenovo has made clear it will. They cannot be needed to obtain final resolution of the entire dispute, because that will happen. nor are they to further some other FRAND rate setting proceeding somewhere else globally, potentially the EDNC, which otherwise would be ignored. We've agreed to undertake to accept that, if it is set, if there's patent peace, and that has been refused. So the real reason, we say, for the injunction campaign is indeed to seek to obtain better terms than might be set in a court-determined licence, and that is a reason why relief can be engaged to hold the ring. And I've shown you why that matters for the current UK proceedings, both proceedings, the FRAND and the 2011 licence, in the passage I will not read out.
Suppose one hypothesises that there were to be FRAND determinations both by the English courts and by EDNC. And I appreciate you pointed out that there's a finding that that's not guaranteed in EDNC, and you've explained the reasons for that. But let's assume, for the purposes of my question, there would be determinations by both the Patents Court and by EDNC. And let's assume also that the EDNC determines the amount payable by Lenovo is higher than the English court. What then?
Well, my lord clearly is aware that the Court of Appeal in Our Planet and also Mr. Justice Mead in Nokia and Oppo explain that where you have, it's a function of the system, but where you have more than one court considering FRAND, then you can have different results and it can be open to the patentee to choose. However, we say that the point about
to choose the result or to choose the court, sorry.
Oh, to choose the result.
Yes.
And that comes down to perhaps an unfortunate element in the system, but the system doesn't preclude more than one court.
It seems a little odd on one view, because one can understand that the determination by the court first sees should prevail, but let's assume that it's the other way around. So the court first sees sets a lower rate than the court second seized. Do you accept that in those circumstances the patentee can choose the determination by the court second seized?
My lord raises a good point. I was not so much accepting as putting out what was being said by the Court of Appeal and by Mr. Justice Mead in Nokia and Oppo. My submission for today is that these sort of issues are difficult issues, and I'm not trying to dodge that, but what I'm saying is the point about today is a holding the ring. And so my lord puts to me a difficult situation which has arisen in Nokia, Oppo and others, and has arisen with courts, in that case it was this court in Chongqing in China, and what might happen on final determinations. And it raises potential issues of res judicata, it raises potential issues of finality, which were not resolved in that case, and to my knowledge have not been resolved in other cases. What this case, in my submission, raises is the holding the ring approach. So it's not an approach where you've got two actions that are proceeding in parallel, such as with Nokia and Oppo, Oppo wanting the determination in China, Nokia wanting it in the UK. Here, we've got actually actions by the patentee Ericsson, one of the patentees, but the patentee Ericsson, which we say are in breach of its obligations. Now, nobody has yet suggested that starting two actions in different courts is a breach of the ETSI obligations. But we say where there is an action proceeding, and for the reasons I have put in the current circumstances, the SEP owner is acting in a way which is contrary to those obligations, and indeed may jeopardize the result, and indeed also means that the implementer is itself constantly the subject of injunction attack on its business, whilst the dispute is trying to be sorted out. Now that engages the principle that we're talking about. So my lord, in my submission...
Your answer to my question, I think, is this. You wouldn't dispute that in principle it would have been open to Ericsson to say, we want Fran to be determined by EDNC, which is first seized, and not by the English courts. And it would be contrary to comity for the English courts to interfere with that. You say, when you look at the facts, that's not what's happening.
That's right. That's not what happened on the facts. In principle, it could be open to Ericsson, although one has to be, that itself raises issues on the cross license. Sorry, I haven't had a note. That raises issues on the cross license, but in any event, my lord is right, that doesn't arise in the current case, because as I've shown you, that is not what they did. I also would say that if in principle they were going to do that, then one should have a patent peace. That may not engage this court in those circumstances, but in the present circumstances it does, because the lack of patent peace, the injunctions are impacting and will impact in our submission on the UK proceedings. And I know I have said it a number of times, and I know my lord has this, but of course there's also the added dimension in this case of the licence, which doesn't arise potentially in other cases. But when one is considering the relief appropriate to hold the ring, and also the actions that a willing licensor or a willing licensee would do in accordance with their ETSI undertaking and obligations, that is, in my submission, important.
Not that this really matters, but is that really right? I mean, you pointed out the significance of the time factor here. If you didn't have the time factor, would the existence of the 2011 license dispute really matter very much? I mean, why shouldn't Ericsson say, well, we'd rather have a determination in North Carolina? So be it, the 2011 dispute can be determined in the UK, but that's fine. We'll see what happens in North Carolina.
Indeed, that, in my respectful mission, ignores the cross-license element and our, so we've got both the 2011 licence and the amount to be paid on our portfolio, could be here in the UK, and that is actually the bulk of the dispute. And on the timing element, my lord is right. One has to be careful slightly on the timing element, in that the late 2026, of course, was back a year ago when the court was looking at it, so it was quite a long way ahead. Now, 2026 doesn't seem so far now, but one has to be careful about what may have happened in the interim on that. One's looking back to when the judge was looking at it and the delay there. So, my lord, one has to be, that's why, to say there's a hard and fast rule in every case, we're not submitting. We are submitting that one is looking at, in the circumstances of what has happened in these proceedings, in this court, is Ericsson acting in accordance with its obligations to ETSI? We say it is not.
And when you say the obligations, you mean the obligation of good faith?
Obligation of good faith, and also in accordance with our right, as was shown in Panasonic and earlier cases, to uninterrupted licence once we have committed. And when I say uninterrupted, it's uninterrupted from being injuncted. Before leaving the authorities and going to the judgment, just briefly on Alcatel and Amazon, you'll find that in tab 22. It's a recent case. That was a dispute under the ITU declarations, not ETSI, and involved a claim for an interim licence declaration, whether it was arguable to amend pleadings. So it's got to be seen in that context. Amazon had committed to take the licence, but Nokia and Alcatel had not. The reason I go to it, actually, is for page 659. Where at paragraph 75, the court again explained the exercise that is being done in relation to an interim licence. And you see about halfway down, there's a passage, a sentence that starts, as can be seen from Panasonic and Xiaomi. And the court explains the question of what terms are found for an interim licence is quite different from the final licence, and determining such terms is a much more limited task. This is because the interim licence is only designed to hold the ring pending determination of the terms of the final licence, and the payments are then adjusted. And I go to that because that is something that the judge did not do in the judgment below. In the end, the pleadings here were it was held to be arguable that an interim licence can be pursued on the facts of that case. So, my lords and lady, turning to the fourth part of my submissions, which is the judgment and why we say he erred with respect in his approach. Starting is his approach to whether Ericsson is in breach of an obligation of good faith to justify holding the ring short-term licence. That is our first ground of appeal as well. And my lords and lady will see the approach of the judge if we take out the judgment in the core bundle. Page 19. It's paragraph 84. He approached the question of whether or not Ericsson was in breach in terms of whether Ericsson's offer was within the FRAND range or not, and whether he could determine that to a high degree of assurance at an interim stage. He explains, sets out at 84 the offer, and then at paragraph 90, having discussed the Newey brief, which I've shown you, at paragraph 90, he says he's in no position to decide at a two-day hearing without expert evidence or cross-examination whether what the Newey had said was correct or not, and that is that the offer was in the FRAND range. It's quite clear that Newey reached its conclusions after hearing or being at a hearing with a lot of evidence, but then he also accepts that some of it had not been deployed before him. And this led him at paragraph 95 to say that, putting it all together, he couldn't be satisfied to the high degree of assurance that in exerting pressure on Lenovo to accept its offer, Ericsson was necessarily seeking supra-FRAND rates. So, and one sees at 96 and 97 that because he doesn't know if the offer was supra-FRAND, he felt he couldn't say whether pursuing injunctions to obtain that offer was acting contrary to good faith. Now, we say that is not the right approach, and with respect, that's an error. It's not right that at an interim stage the court has to start deciding whether offers are or are not within a FRAND range, as the judge actually rightly set out. He could not do that without sufficient evidence and cross-examination and the like. Moreover, it's not the making of the offer that is the breach that is relied upon. It is, as I've explained, continuing to seek and enforce injunctions in the circumstances of the current case. Now, the judge was aware of the likely answer, perhaps, to the question that we say is the right question to ask, and he did look at that at page 112, sorry, paragraph 112. Where he says he can see an arguable case that Ericsson is in breach of good faith on the basis that whatever Ericsson's frustrations on the negotiating stance in the past, Lenovo has undertaken to accept English court's determination of FRAND terms and even EDNCs. It is certainly arguable, he goes on, that given Lenovo's offer of undertakings, Ericsson is exerting unfair and unreasonable pressure in pursuing injunctive relief when it should be negotiating towards a FRAND rate. But he goes on in 113 to say he's not satisfied that this arguable case reaches the threshold of a high degree of assurance, but his reason for that goes back to that he doesn't actually know if the offer is suprafrand. And that's, he explains in paragraphs 83 to 97, which is where he went through his concerns over is it or is it not suprafrand. At 117, he says, although he said the undertakers are important, he said their significance is reduced because only one side has undertaken. We do not agree with that. The bottom line remains that Lenovo has undertaken to take a license settled by the court and is trying hard to ensure it happens in a timely fashion, but is still subject to injunctions. And at 120, he accepts again that Ericsson is seeking to exert commercial leverage over Lenovo, but again goes back to his earlier findings to say he can't conclude in the circumstances of the case that it's failing to act in good faith, but he certainly agrees that it's arguable. And we say again, what the judge had failed to appreciate is it's not that Ericsson's offer is FRAND or not that is the issue, it's why are they going down the path of suing in many multiple jurisdictions, or 3 jurisdictions, I shouldn't exaggerate, in 3 jurisdictions for injunctions. And we say it's actually because it wants to avoid the court scrutiny and secure better terms than it fears it would result from a court assessment. So we say the judge's approach is focusing on the wrong thing and led him into error as to whether there was a breach. As to the second made error, again, this is, if you like, to the exercise itself, what he thought he was doing. And we can pick that up at paragraph 103. He recorded our argument that there's nothing special about a short-term license, and that goes to the fact there was debate at the time about whether it's interim relief and bringing in interim declaratory issues, where it's in fact final relief for the interim period, a short-term period, and that we argued that it is still must result in the basic obligation of clause 6.1, obliging Lenovo to offer it. We argued that it is final relief for a short-term period, and we stand by that, and it's what a willing licensor and willing licensee would agree, and must therefore be FRAND.
I mean, it may be a terminological point and of no importance, but according to the judge, you submitted him, or counsel then acting submitted to him that it was wrong to describe as an interim licence, but certainly in this court, it's part of your argument that in substance it is an interim licence because, as you've repeatedly emphasised, it's designed to hold the ring. So, which is it?
Well, it is, in my submission, it is a final determination of holding of the interim position in order to hold the ring, and so it sets out what willing parties would do between now and trial, not in a way that will be revisited at the trial, save for the adjustment clause, and that is what makes it, in our submission, FRAND, if you like, or ensures that it's FRAND, because we say a judge at a 2-day hearing such as these cannot sensibly determine whether or not the amount that goes in the licence is in fact FRAND. That is, I think Mr. Justice Mead has referred to that as a conundrum that can't be answered because it requires evidence the judge simply won't have. So it is a licence in order to hold the ring, but it is not to be revisited all over again at the trial. You don't revisit everything. What you do is at the trial, then determine what is the actual amount, and then the adjustment clause kicks in and will either go up or go down. And so that is what we say it is, and that we say fits with what the court said in Alcatel, where it was clear that the exercise is not 2 FRAND trials of the same scope, one to work out what's FRAND now and one to work out what's FRAND.
Your submission is that the approach taken in Alcatel was correct.
Yes. And that is why, with respect to the judge, we say his approach was wrong. And one sees that at paragraph 105, where he rejects the approach of a hold the ring. He goes on in 105 to say he's prepared to assume without deciding that willing licensors and licensees might be prepared to adopt a more rough and ready approach. But then in our submission, he was confused by what was meant by if the short-term license is to be analysed as a specimen of a normal FRAND licence, then the terms need to be FRAND. In our submission, what ensures it's FRAND is the true-up or adjustment clause. So we say at 105 he rejected the hold the ring approach, and we say he was wrong on that. And one can see how it leads, because what it leads then is a court in a 2-day hearing trying to decide whether terms are FRAND, and one can understand immediately the issues of that, which he himself set out, that he simply did not have the evidence and cross-examination in order to do that. And you see that at 108 at the bottom. Following a short hearing with no live evidence, comparables, expert valuation, I can't make that decision. And we agree with him that that can't be done. Where we part company with him is that is the exercise that is required. He also, at paragraph 109, did not feel he could split the difference, which is the Court of Appeal did in Panasonic, between the two rival offers with an adjustment clause. And he says that the Court of Appeal was prepared to do that, but in the case for him, Ericsson had not proposed any terms. So all he had to go on was Lenovo's proposal and what Lenovo's evidence was about Ericsson's case. And we say it can't be correct that a party can avoid a short-term license by refusing to engage. If Ericsson had taken issue with Lenovo's understanding, which the judge held would lead to a payment at that stage about 3 times higher than Lenovo was suggesting, he records that in paragraph 100, Lenovo should have put in evidence, even if it caveats it by saying we don't agree.
You mean Ericsson?
Sorry, Ericsson, even if it doesn't agree. We say it's not right that Ericsson can stand back and do nothing and avoid it for that reason. Now, stopping there, we say these 2 errors, one on good faith and the approach, and one on the exercise itself, are sufficient in our submission to entitle this court to re-exercise the discretion. But we also say the judge erred in his approach on both the accounting point that was raised by Ericsson and useful purpose and comity, and I will address those briefly now. First is the accountancy point, that Ericsson said that a payment from a short-term license could not be recognised in its accounts. Now, it's important to see the evidential basis for this, which is in our submission shallow, and one sees that in the supplemental bundle, tab 17. On page 181, which is the second statement of Mr. Foster. And at the end of paragraph 11.1, he says one can assume that Lenovo is aware that such interim payments, even if they're made directly to Ericsson, would not be final, and so would not constitute revenue under generally accepted accountancy principles. He came back to that in his 5th statement in tab 19 on page 211. Where in paragraph 77, he again refers the lack of finality. An interim payment is not final, as it would be subject to an adjustment and therefore would not be recognisable under generally accepted accountancy principles. And on page 215, in paragraph 88, he talks about it not in the middle of the paragraph, just below the first hole punch, it not providing Ericsson with any payment that could be recognised as revenue under generally accepted accounting principles, and then he goes, meaning Ericsson could not use that money until a final licence is signed. Now, nowhere did Mr. Foster identify the accounting principles concerned, and he obviously wasn't giving evidence as an expert accountant, And we don't have information about their accounting period or which accounts he's talking about, such as statutory or internal management accounts. The main point being made was finality. My Lady Justice Falk held in Bull Holdings that accounting standards are not legal documents like contracts or statutes, and you normally need proper accountancy practice evidence as a question of fact.
My lady is familiar with that judgment, but speaking for myself, I'm not. So could you show us the passage?
Yes, of course. That is in JA Bundle tab 9. Starts at page 147. The passage I was referring to starts at paragraph 30 on page 158. Where my lady was talking about, at the heart of the appeal, the question is whether the correct interpretation of accounting standards, and there was a particular one there, FRS 23, to be characterised as a matter of law or fact. And over the page 159, she actually, my lady cites a judgment of my Lord Justice Arnold's in Smith. Where both parties agreed that the part of the ratio of Mr. Justice Arnold, as he then was, decision was his conclusion that accounting standards are not law, and the interpretation was a matter for the FTT unless was no reasonable tribunal could hold. And then my lady, in this case at 37, goes on to explain and find that accounting standards are not legal documents, they're not statutes or contracts, and therefore at 40, it's a question what is generally accepted, as well as the question whether a particular set of accounts are prepared in accordance with that, is a question of fact to be determined with the assistance of expert evidence and professional accountants. And then she agrees again with the approach that my Lord Justice Arnold took in Smith. Now, we don't have anything like that here, and really the only point made in the evidence was that it went to the lack of finality of the award. It can't be booked as revenue in the accounts. Of course, if that's right, that could be said of any interim damages award or any interim costs award, or indeed a finding of what the Fran terms are following trial and pending appeal. But in my submission, it can't follow that they are not worth awarding. And also, we say the judge read rather more into this than was in the evidence, and that is in the core bundle, tab 1, para 101 of the judgment, and 102. Where at 101, he went on to say that the problem may be that Ericsson might be found a net payer to Lenovo, which was an issue at the outset. Sorry, Lord. It was paragraph 101 of the judgment. I think my lady's there. He therefore read into it that potentially the accountancy rules would require Ericsson to recognise a contingent liability equal and opposite to the asset, considering the lump sum, recognising the risk it may have to repay that lump sum. That does not arise from the evidence. Whether it's right or not, it is not in the evidence. He also then went on in 102 to say that halfway down, that Ericsson is a listed company, and so it's reasonable to suppose that its published accounts are of interest to a number of stakeholders, creditors, shareholders, potential investors. Of course, we don't actually know which accounts were being discussed, and therefore he thinks there's nothing obviously wrong with Ericsson's assertion that cash it receives can't recognise for accountancy purposes. And he then says it will be invisible, in inverted commas, as far as key stakeholders are concerned. That does not come from the evidence, the totality of which I have shown you.
I wasn't paying sufficient attention. Does any of that sentence come from the evidence?
No, any of that sentence. What does come from the evidence, I think is fair, is that Ericsson's assertion that cash it receives cannot be recognised for accounting purposes, because they said...
That doesn't obviously lead
no,
on.
No.
Yes,
So all we got from the evidence is it can't be recognised in some accounts, we don't know which, and really the issue in my submission was the interim nature of it. And you have my submissions as to why we say that cannot be determinative. I mean, the money is still in Ericsson's cash reserves. Now, the court held in Panasonic, para 55, that actually any business is likely to want rather to have use of money now than rely on inadequate compensation later. And it should also be remembered in the specific field that we're in, that the Court of Justice explained in Huawei and ZTE that willing implementers should provide appropriate security in accordance with recognised commercial practices, for instance, by way of bank guarantee or placing money in deposit. And that was recorded by the Supreme Court in paragraph 214 of their judgment. And my Lord Justice Arnold in Interdigital and Lenovo, at paragraph 36, agreed with the trial judge that a willing licensee under the ETSI regime might well make certain payments on account to demonstrate willingness flowing from the ETSI materials and guide, which refers to implementers making financial contingency or payments ultimately payable. We say if this accountancy point is a good one, then payments made under Huawei ZTE or best practice in IDG and Lenovo appear to be of no benefit to a SEP owner who can refuse them in favour of continued injunctive relief. And we say that doesn't accord with the ETSI framework. And if I may put it colloquially, it does seem to be the tail wagging the dog. It's elevating accountancy practice of some sort, of which we know almost nothing, over substance.
I mean, it's a matter of common sense. It seems plausible that if you have a potential liability to repay, that will be treated by accountants in a particular way.
Yeah.
But maybe it goes no further than that.
I think that's right, my lord. I don't think we can say, I'm not submitting to my lord that it is implausible, that it cannot be put in various accounts.
You didn't file any evidence to contradict it.
My lord, a fair point, but also there's not much to contradict. And what the judge has done is taken it further and also elevated it in a way that we say takes it beyond the substance.
So haven't matters moved on anyway? Because as one sees from 101, as at the time of the hearing before the judge, Lenovo's position was that ultimately Ericsson will be found to be a net payer to Lenovo, whereas what we now know is that your clients now accept that you will be net payers.
My Lord Justice Arnold is absolutely right. My hesitancy of raising that now, I was going to raise that later, was that is in the evidence that I had agreed with my own friend not to refer to. So I was merely going to come to that in that is in our skeleton argument referring to the evidence of Ms. Dagg in 13. So
just pursuing that, I mean, suppose it were the position that it was undoubtedly the case that you were going to pay £1, but no more than £1. If this is the accountancy principle, then there would still be a potential liability to repay all but £1.
Yes, one would assume that would then be set out in the accounts, and so it would be known why the money had been received and on the basis, and also that there's a liability attached to it. Again, it's difficult to know the harm that then follows from that.
Isn't that the key point about tail wagging the dog? What you have to work out, even if the point's right, what you're comparing it with.
Yes.
Presumably, the comparison is maybe that Lenovo accepts Ericsson's offer, and the trials don't happen.
That's right.
Including the EDNC trial, which Ericsson says effectively is its preferred forum. Because otherwise the UK trial would determine the position finally well in advance of what seems of that trial. So I don't really understand where the accounting point goes in terms of being unhelpful to your case.
Well, I agree. I mean, I'm discussing it because the judge thought it was unhelpful to our case, but I don't see, in the end,
We have to work out what you're comparing it to.
I think that must be right, my lady, and also we say that what appears in the end to be the real objection again is court review, because the reason it is temporary, it being the amount, and is open to adjustment, is adjusted by court. And so again, we go back to the only way the amount at this stage can be final is if we agree Ericsson's offer. Anything other is not going to be final.
Indeed, one might make the point that if the concern is a risk of having to repay it, that doesn't, emphasising that point also doesn't perhaps assist Ericsson's case.
My lady's absolutely right. So we say, again, that this point, although it did gain purchase with the judge, should not have done.
So just to understand how it could fit in, without having properly in mind what the judge said, I mean, supposing it were the case that when Ericsson gets in some money, it can't do anything with it. Is that something that could be taken into account when deciding whether one can have a high degree of assurance that they are acting in breach of good faith in declining to enter into a short-term license? The theory being, well, if they do, they're not going to get anything that's really valuable to them.
Well, the difficulty there, my lord, is that it's the one-way nature of that, in that it's looking at it purely from their perspective, and yet the corollary is what they say they therefore can do is continue injuncting the implementer and causing what is real harm.
That's really my point,
Yeah.
because the only way they're going to get secure money that isn't affected by this accounting point in short order is by Lenovo agreeing to a license on terms that Ericsson are
Exactly.
prepared to agree. Otherwise, there will be a final
That's right.
determination.
My lady is right. And so when looking at it from both sides of the coin.
And just thinking around that, I mean, this is a question of French law, I suppose, how the obligation of good faith works, because it's a French law obligation. Do we have any guidance as to how far somebody with that obligation has to take account of the interests of the other party, or can take account of what's in it for them?
Well, we have it. We have the findings. We have it. The obligation is to negotiate in good faith. We also have the findings of the court in Panasonic that the implementer has a right, once it's agreed to take a license from the outset, and also uninterrupted by injunction. And we also have the findings of, as I've said, the Court of Justice and this court in Interdigital about how good practice might be to do just this and put money aside and put money towards the issue. On the very basis, one doesn't know the amount until the end, but one can assist in resolving the issue that a willing licensor and a willing licensee. And in my submission, where there are some areas of plausibility, in the sense it's plausible that there may be accountancy, I'm not quite sure which rules or which accounts, but I can't stand before you and say it's implausible. But what we say is not plausible is that a willing licensor who's truly willing and is offered hundreds of millions of dollars now, albeit to be adjusted later by a court, would refuse that and has actually got a right to refuse that and instead impose real harm on the implementer by injunctions. And that we say is not the right approach.
I should just say that one sentence in the evidence does strike me as implausible, which is an assertion that you can't use the money.
You're right.
Whatever accounting principles require, they can't place a legal impediment on using the cash.
Yeah, it depends what's meant by that, and it's in a parenthesis at the end. But it can't. What's been said in the previous statements, which is certainly what the evidence seemed to be, is that it can't be, if you like, booked as revenue.
That's a different point.
Which is a different point. My lady's right. And part of how this was used, as I'll come to by the judge, is coming into an assessment of whether the making of the declaration would serve a useful purpose. because partly, and you'll see that at page 128, paragraph 128, on top of page 28, sorry, where he thought that there was a likelihood that Ericsson would conclude that since the lump sum cannot be recognised for accountancy purposes, it's insufficiently worth having to outweigh the disbenefit of having to give up its injunctions. And again, we see that's all one way. And frankly, that there isn't sufficient evidence as to what this harm would be.
But in this context, it doesn't matter whether it's one way or two way, does it? I mean, this is trying to assess whether Ericsson
That's fair.
would accept the position, and there it's obviously entitled to look to its own interests, not yours.
That is right. That's right, my lord. Of course, way one looking in the context, and we'll come on to whether or not it serves a useful purpose. Is the point here is that objectively we say that is still a breach of their obligations. Say, well, I'm not going to take that money for accountancy reasons, and I'll continue to injunct you instead. In my submission, does not mean that they are acting in good faith.
Yeah.
Which brings me to utility and comity, our appeal grounds 3 and 4. And the judgment picks this up at paragraph 121. And the judge records 3 potential purposes. In little 1, he talks about the declarations being of some relevance to the courts abroad in relation to the injunctive or similar relief. In 2, forcing Ericsson to reflect on its course of conduct and cease pursuit of the injunctive relief. And 3, holding the ring to preserve the utility of both the 2011 licence proceedings and the FRAND license, cross-license proceedings, rather than that being diminished by Ericsson's pursuit of injunctive relief. And we do rely on all 3 reasons, but starting with reasons 2 and 3 in paragraphs 121, we say that the judge was wrong, reject those as useful purposes. We say that the declarations may well assist in protecting and designed to assist in protecting the English proceedings and getting Ericsson to reflect on its course of conduct. We say Ericsson's conduct is directly aimed at frustrating what we say it should be doing under its obligations. And we look at what the judge said as to why he rejected them at paragraph 127, where he says there's not much utility in 1212. He says that there's no point contrasting the facts with Panasonic, but that's the point at the end of the top of the next page, where there is a likelihood Ericsson would conclude that since the lump sum payable of the short-term licence can't be recognised for accounting, it's insufficiently worth having, and we say that is to elevate this accountancy point beyond the evidence that supported it. And he also then proceeds in 129, halfway down, to say that, in my judgment, there's every prospect that Ericsson might conclude that its strategy is working, and it might lead to an agreement at or around the terms of the October 2023 offer. What he's actually saying there is there's a prospect that Ericsson will just ignore it and proceed because it gets what it wants. Now, we say that's not a reason not to make the order, that is a reason to make it. And on top of that, we don't agree that it will not affect Ericsson. We say, actually, they are a well-known SEP owner. They have signed up to the system, and it is every likelihood that if this court was to hold that this approach is not in accordance with their obligations, they would take note of that, just as Panasonic did. At 133, because he's rejected the previous reasons, because he says Ericsson might think it's better off ploughing on with its strategy, he therefore says all that's left at 133 is an attempt to influence foreign proceedings by offering an unsolicited opinion on matters that overseas courts and bodies need to consider for themselves. Well, we don't agree with the premise that that is all that's left. We also say he rather underplays the potential utility to foreign tribunals. As to Brazil and Colombia, he did describe the utility as slender, but he rightly accepted that it's developing jurisprudence in both Brazil and Colombia.
Well, what do we in this jurisdiction, what businesses with ours to influence what's going on in Brazil and Colombia?
I completely agree, my lord, if that was the only reason for the declaration. I'm not suggesting, if it's right that the only reason for this declaration, or the only purpose of the declaration is to influence those, then I agree with you. I'm not submitting otherwise.
Well, I fully understand that your argument is that this is not the only purpose, and indeed you put the other two purposes higher in your order of priorities. You're still maintaining that this is a purpose, and so my question is it a legitimate purpose?
Well, my lord, there's no question, as was said in Panasonic, there's no question of this declaration forcing or requiring or trying to intervene in those other proceedings. As was said in Panasonic, if Ericsson were to change its position and accept the declaration, then in my submission there's no comity issue. As was said,
That's a different point. That's looking at what happens if the declaration has its desired effect.
Understood.
But the question here is, what if it does not have the desired effect? And as I understand it, your argument, albeit it's a subsidiary one, is still that it's a legitimate purpose to seek to influence foreign courts. And I'm asking, why is that legitimate?
I'm not suggesting it's legitimate to influence foreign courts. My position would be that if they did not accept it, then it will be up to those foreign courts, just as the court explained in Panasonic. And those courts would be entirely free to consider or not consider that a declaration as they see fit. And so we say that, as my lord rightly puts our submissions, that the primary position we look at is the potential utility in protecting these proceedings aimed at Ericsson. And if Ericsson complies with the declarations, that does not offend comity any more than we say that our planet declarations, final declarations would. And the issue that the court would be declaring is what a willing licensor acting in accordance with ETSI obligation would offer in the circumstance, or agree to enter in the circumstances of this case, pending determination of the dispute. That's not an issue which arises in the foreign proceedings. Foreign courts are seized or in better position to opine on that issue of French law in this court. And none of the other foreign proceedings are definitely considering the appropriate FRAN terms of a cross licence, including the 2011 licence dispute.
Can I just make sure I have understood that? The North Carolina proceedings would never address the cross licence, is that correct?
As I submitted, what the North Carolina proceedings will address is uncertain, as the judge held.
Yes.
On a conditional basis, if they found that Ericsson's offer was in breach of FRAND, then they might go on and consider the issues of including the cross license.
Oh, I see. So
But
on
it's
the
conditional.
if they get that far.
If they get that far, and that was where the importance of Ericsson being asked to change their claim
yes,
to allow that. And so we say, and we do put our case primarily on the basis, and similarly to Panasonic.
I'm sorry, it may be worth teasing out one point, which I think is very implicit. Maybe it's worth just actually focusing on it. The October 2023 offer is of a cross license. It may attribute no value to the Lenovo portfolio, but it is nevertheless an offer of a cross license, correct?
That is correct.
And it has to be, because otherwise it would be non-compliant with the ETSI rules.
That is right on, yeah, that's right.
Yeah, so one needs to be a little careful as to whether it's formally a cross license, yes it is, and whether it attributes value to the Lenovo portfolio. You say no, it doesn't, but those are, one needs to distinguish between those two questions.
My lord's right in the sense that it is an offer for a cross license attributing either no value or limited value, because they say it's the same, I think, the same value as the HEVC SEPs. And so my lord is right on that. Of course, it doesn't change the fact that if making an offer of that nature falls within the Microsoft type approach of being within the obligations of ETSI, i.e. not a breach.
Yes, I'm sorry to interrupt you, but I think your point about the reason why there's no value is accurate. When you look at what the judge says at paragraph 82, little Roman 4, the reason why no value is attributed to the Lenovo portfolio is because it's assumed to be equal and opposite to the H26X. What's H26X? I've come across H265. Anyway, that may not matter.
I may not be able to help you on that, but I've been thinking of them in HEVC. But
Well, H265 is HEVC by another name.
that was what my understanding. But my lord is right, and I'm glad I'm thankful that I was accurate in what I said. But
Yeah, all right.
and of course, my lord will understand that at the Fran trial that Mr. Justice Mead will be hearing in April, one of the debates is whether that is right and the actual value, both actually to the portfolio that is Lenovo's, but also as to whether or not value should be attributed. There's an argument about whether the HEVC products should be included as into the scope without additional value, or the value is already baked in, or whether additional sums should be paid, and that is.
Okay, thank you.
I have just, for my lord's note, apparently H26X is intended to cover H264, 265, 266 and future iterations. So it's an X as in fill in as appropriate. My lords, finally, before I sit down, I come to the fifth and final part of my submissions, which is, if my lords and lady are with me that the judge erred, what we say should be done in re-exercising the discretion, and that's where the new evidence of Ms. Dagg on her 13th statement comes in. My lords will see that in core tab 21. I won't obviously go through all this now, but just the headings. She updates the court on what has happened in the proceedings in England in her section A. And her section B updates the court on the ITC proceedings. In effect, nothing has changed in timings of that than was before the judge. At paragraph 9, she updates on the EDNC and says that although when the judge heard this in a year ago, the evidence was the DNC may come to trial in the end of 2026. She updates the court that in fact the court has yet to issue any scheduling order and that the proceedings remain dormant and has been for more than a year. And then she updates the court on the proceedings in Colombia, where Ericsson are continuing to try to expand and pursue their preliminary injunctions there. And she also updates the court on the UPC, where actions have been continuing against Ericsson there. But again, as she says in 14, very clear, as we have been all along, we won't seek and enforce patent injunctions or exclusion orders anywhere in the world if Ericsson will do the same. So these are defensive, responsive proceedings. And it's unfortunate, and we say again, one of the problems is this proliferation of proceedings. And then she turns to update the court on the offers and how things have changed. And as my Lord Justice Arnold rightly pointed out, now there's no longer the case where there's a question that Ericsson might be net payer. And one can perhaps pick up where we get to on that from the table at the back, which is in paragraph 200 in the time available. Sorry, page 200. And what Ms. Dagg has done is, in light grey and dark grey, set out the rival positions as she understands them, and we've had no evidence back saying this is wrong from Ericsson, based on the evidence filed for the FRAND proceedings to take place in late April. And in the light grey, we have Lenovo's position, and we see that there's no dispute now on the per unit rates for 4G. We see that there's the rate there of which, well, actually there's a higher rate there for on Lenovo's evidence for 5G handset, tablet, laptop or PC units. We see that there is a dispute on 5G handsets. That is due to scaling for 5G only, because some of those Motorola handsets Lenovo say are licensed, and that is why there's a difference in the per unit rate there compared to in Ericsson's line K, row K. And then there's a rate for non-cellular HEVC units, which is part of Lenovo's case, that if it has to pay for those, that is the per unit rate, whereas Ericsson's case that's a set-off. You can really see here the difference where the real dispute lies, and you can see that in the volumes for 4G units, and you can see that in row A compared to row I, and that is the license dispute. The 2011 license dispute on Motorola, that's the majority of the 4G. And there are also quite big, or there are disputes on revenues that you see, for instance, in row D and with the non-cellular HEVC units. None of that will be considered in the ITC or anything like that. But what Ms. Dagg then does is she says, well, in the first yellow block, in the Lenovo light grey, I won't read it out, but under royalties, you see the amount that Lenovo says is payable, and then a sum removed for the short-term license, so to the end of this year, which is the second yellow figure, which gives you a net sum, and with interest, you get the bottom of the first bold yellow in row H. Now that would be Lenovo's case on what it would be reasonable to pay based on its evidence for a license, a short-term license, to 31st December 2025, when judgment on the FRAND trial will be expected and the court can consider
All
it
of
again.
these figures are confidential, and of course I'm not going to therefore say anything about precise figures, but would it be acceptable to refer to the orders of magnitude?
Yes, there's nodding behind me, my lord.
Thank you.
And one can see already, so that would be Lenovo's position. Now what Ms. Dagg then did was to say, well, looking at Ericsson's evidence that they have served and going through the same process, one gets to a net payment that it appears that Ericsson would be requesting for the same period, with interest, with the figure one up from the bottom in row M. And so the difference between the two on this evidence, based on what's been filed for the FRAND case, is between H and M, and cognizant of what the court did in Panasonic, she has therefore given the midway point at the very bottom. But she also makes clear in the evidence that Lenovo would pay any sum that the court holds is reasonable to pay. So we're not attempting to straitjacket the court, not that we could, but that isn't what we're saying. We're giving, based on what was done in Panasonic, what the midpoint would be. And plainly that is higher, a lot higher than was before the judge, but that is because things have proceeded and gone on and the evidence has been.
And to be absolutely clear, that would include, say, paying the Ericsson figure.
That's right. What we've done is we've taken the
Sorry, but when you say you'd pay whatever the court thought fit,
Oh,
so if the
yes.
court thought fit to say, well,
I see. We're not going to split the difference. We're going to say what you've
Yes.
put there. Yeah, my instructions are that we would pay whatever the court thinks is fit.
yes, I see.
My lord, we say that a sum of those sorts of figures are the sorts of sums that Ericsson is going to be likely to accept, and certainly an accountancy point is not going to get in the way. And we say that a willing licensor and licensee would enter into a license of that nature to be adjusted by the court, and the court parties could then focus on the jurisdiction, the only jurisdiction that we know will resolve the whole dispute. And we say, therefore, commend that approach to my lords and lady. My lord, I have got to where I said I'd get to, or thought I'd get to, with my learned friend. If my lord and lady have any other questions.
Thank you very much. Mr. Pickford.
Thank you, my lord. Just bear with me a few seconds as I rearrange the equipment. My lords, my lady, the scheme of my submissions is I'd like to make a few introductory remarks. Then I'm going to go back very briefly to some of the facts as found below, just to fill in a couple of gaps. Then again to the Panasonic judgment. Again, we've been to it, but to take the court to a few points that we say it should also bear in mind. Then I'm going to address the grounds of appeal, and then I'm going to address my respondent's notice. That's the scheme. So to begin then, we say one of Lenovo's central problems before this court is the following difficulty. It knows it must do better than seek relief with the intention of influencing foreign courts, but it has no sustainable case on this issue. Now, what Lenovo says is, I quote from its skeleton, but we've heard a very similar position advanced this morning. The primary purpose for which Lenovo seeks the declaration is to force Ericsson to reconsider its unlawful conduct in the UK. But Lenovo are unable to explain what is unlawful about Ericsson's conduct in the UK. Ericsson has brought no proceedings here. It has sought no injunctions here. It challenged jurisdiction here, as it was entitled to do, but having lost that battle, it's cooperatively taking part in the proceedings. And crucially, it's made no promises to the court here to enter into a license on terms that this court determines to be FRAND. So there is no undertaking on that score that it can be acting inconsistently with. That is all to be contrasted with the situation in Panasonic, as the court will appreciate. Panasonic, having brought the proceedings in England to have FRAND determined here, and having given mutually binding undertakings with Xiaomi to abide by the court's determination, then abused, we say, the English proceedings by seeking to render that undertaking effectively nugatory, because it brought parallel proceedings in a foreign jurisdiction. Now, in truth, what Lenovo wants is to obtain relief from the English court, which it believes will influence proceedings elsewhere in the world. Ericsson is a Swedish company, Lenovo is a Chinese company, and they're obviously engaged in a worldwide patent dispute. Their dispute, we say, in fact, has a particular commercial focus in the United States, where they have both brought proceedings against each other before the United States ITC. And there is also litigation, of course, as has been mentioned, in the United States EDNC. Now, it's clear from the evidence that it is those US proceedings, and in particular the ITC ones, which are of most commercial concern to Lenovo. And it's seeking to avoid injunctive style relief being granted by the ITC. That's what it wants to do on this application. And so what the Lenovo is asking the English court to do, we say, yes, of course.
Do you submit that it is illegitimate for an implement which is prepared to commit unequivocally to enter into a license on terms determined to be frowned by a court to resist the grant of injunctions by the SEP owner?
It's not illegitimate per se to resist the grant of injunctions. It depends what injunctions we're talking about and where.
But you seem to be, the reason why I asked the question was that you seem to be implying there was something illegitimate in Lenovo's objection to what was going on in the ITC. And I'm wondering what's wrong with their objection, because the whole point of the ITC proceedings is to exclude Lenovo from the US market.
Yes.
And that's perfectly legitimate if the SEP owner's concern is that it's faced with an implementer guilty of holdout.
Mm-hmm.
Because the whole point of the injunctive remedy is to force the implementer to come to the table and take a license.
Yes.
But how does that rationale operate in circumstances where, even if rather late in the day, and you say in this case very late in the day, after 16 years, or maybe less than 16, maybe 15 years, but anyway, a large number of years, the implementer sees the error of its ways and says, okay, we accept the game is up in terms of holdout. We will now commit to take a license on the terms determined by the court to be frowned. That rather changes the ballgame, doesn't it?
Well, in my submission, the key point that's missing there is that it does not get to choose the jurisdiction in which that happens.
Fine, but the ITC doesn't determine frown, does it?
Well, that's only a practical problem for my clients, because what the ITC will do is consider whether Ericsson's offer is within the frowned range. That's common ground. So there are two ways in which those proceedings can go. Either the ITC agrees with the OUII and it considers that Ericsson's frowned offer is within the frowned range, and if it thinks it is within the frowned range, then it will be able to grant the injunctive relief that we are seeking. And we say there is nothing unfair or wrong with that. Of course, my lord is entirely correct that if it doesn't come to that view, if its view is that Ericsson's offer is supra-frowned, what it is not then going to do is give us a second opportunity by saying, but here is what a frowned rate would be. So now the question is Lenovo are you going to offer that? And is Lenovo going to take that? In which case, we may yet grant injunctive relief if Lenovo don't take the determined rate. But the fact that it doesn't act as a rate setting body does not mean that it doesn't consider frowned properly and fairly within the scheme that's been set up within the United States to deal with these issues. So in my submission, it is illegitimate for Lenovo facing perfectly ordinarily brought injunction proceedings before the ITC, which of course it always forgets to mention, it's doing exactly the same thing to Ericsson. The difference is we believe it thinks it's going to lose those proceedings. And so as an attempt to stymie our ability to get relief that we are totally entitled to in those proceedings, it wants this court to grant it relief, which it thinks will have one of two consequences. Either we will enter into the license, in which case we won't be able to pursue that relief before the ITC anymore, obviously, because we're seeking to exclude them because they're not licensed. And if they're licensed, then that falls away. Or, at the very least, they hope that the declaration can be waved around to say, well, look, Ericsson are acting in bad faith. You can infer that from what the English court has said, and therefore you still shouldn't grant the relief.
So you put forward the two possibilities.
Yes.
The first would be a perfectly legitimate aim, would it? The hope that getting an order from this court would encourage you to enter into a license.
Well, other than the fact that what's behind it is quite plainly that they want to deprive us of our ability to obtain relief before a jurisdiction where we're entitled to obtain relief, which is the ITC.
Well, certainly that they hope that if you enter into a license, then that will hold the ring until there's an effective determination. I mean, that's not objectionable.
Yes, I mean, it's obvious there's nothing objectionable in them making us an offer of an interim license. There's nothing objectionable in saying, here, wouldn't you prefer to have an interim license? And we can take that or leave it. And as I would like to come on to explain, our position is we most definitely leave it because it offers us very little. And in particular, it deprives us of the ability to obtain the relief that we are perfectly lawfully trying to seek before the ITC, which is the commercial heart of this dispute. Because of course the declaration comes with the stick that if we don't accept it, we are branded as unwilling. And that's the particular point that we say is pernicious from our point of view.
Do you mean branded as unwilling for the purposes of a foreign court, or for what other purpose?
Well, for the purposes of, in order to get to the situation where the court agrees with Lenovo to grant the relief, it will have to have made a finding that Ericsson is acting in bad faith, in essence, because the relief says a party in Ericsson's position would cure that bad faith by entering into an interim license. And so it's not an entirely, it's not divorced from there being a serious problem from our point of view, that declaration, even if we are able to turn it down. And we say we would not accept the license, but that's not the end of the matter, because if we don't accept the license, then the implication of it is that we have acted in bad faith. That's what Lenovo would no doubt say. And we say that is wrong, and that's one of the reasons why this court should not grant that relief. So if I can then continue, what Lenovo seeks to do is align itself with the position in Panasonic, where it says that the relief is necessary to protect the integrity of the English proceedings. But since we haven't done anything wrong in England, CF Panasonic, what that really means is that Lenovo would prefer that it's the English court that makes the determinative pronouncement on Frand. It makes no attempt to hide that what it's trying to avoid is the ITC potentially making a pronouncement on Frand, not a determination of it, but nonetheless a potentially very important pronouncement that Ericsson's offer is within the Frand range. What we say in relation to that is...
Can I just ask you, what's wrong with the UK court determining Frand? I mean, your client's position is that the October 2023 offer is Frand. And the Patents Court may say that you're absolutely 100% right about that.
Yes.
In which case, because Lenovo have committed to take a license on those terms, you will get everything that you're asking for. What's wrong with getting everything you ask for?
Well, I don't say that there is anything wrong with the English court determining Frand. We've got, other than, of course, the point that your lordship made earlier on, which is that one of the difficulties with both the English court determining Frand and very likely the EDNC determining Frand is that we have parallel proceedings, and that is not necessarily a particularly sensible idea. So there is that answer, and of course it was the EDNC and the ITC which are first seized. The English court is the third seized forum dealing with Frand matters. And the answer that I give to, well, what's wrong with that is it's not per se the English court determining Frand. What's wrong is that we have to agree to accept to effectively be bound by what the English court does, because we brought proceedings first before the EDNC.
Yeah, well, that is an
And the
argument I
ITC.
quite understand, and it was what I was exploring with Mr. Nikodopoulos, because I quite understand the proposition that says, yes, FRAND ought to be determined, and it ought to be determined by the court first seized. But of course, if that was your client's position, you would be content for EDNC to determine FRAND, so you would make the amendment to the prayer that the judge thought was necessary, and you wouldn't be pursuing the ITC proceedings.
Well, in my respectful submission, we are quite entitled, particularly against a implementer who has held out from taking a license now for 16 years, to pursue relief that we believe will be commercially effective, and it is quite, and also to bring a lawful commercial resolution to the dispute sooner rather than later. Now, we commenced the EDNC and the ITC proceedings at the same time. As matters have transpired, it is quite clear that the EDNC is going to be a lot slower than the ITC. And so we say there is nothing wrong with us pursuing relief that we are entitled to pursue before the ITC. If Lenovo's got a problem with that, of course, it has access to the US courts, and it can say, well, you really shouldn't be. It could go to the EDNC and say, well,
So the proposition is that you will do better in the ITC than you're going to do as a result of any court determination of what is FRAND.
no, not necessarily. The proposition is that currently there are certain advantages for us that we see in the ITC proceedings that are perfectly legitimate advantages for us to pursue. The first advantage.
You exclude them from the US market and therefore force them to accept your offer.
Well, in my submission, that is the institutional framework which the United States have set up in relation to patent enforcement, including of SEPs, and we are quite permitted to avail ourselves of that framework, just as Lenovo use it against us. So that's the first point. Second point. So yes, it is a point of particular commercial leverage, and it's legitimate commercial leverage. Second point.
What legitimate because because the right exists under American law.
Because the right
for some
exists under
other reason.
American law, and because all the parties are agreed that the ITC is going to consider the FRAND defences. So Lenovo has said you shouldn't grant this relief because this offer is supra-FRAND, and that has been considered by the OUII, and there's no evidence that it's indeed it's the evidence is going to be considered by the ITC itself.
I mean,
so
just take it by stages. That the first proposition, well, it's legitimate because it's possible under a particular legal system in the absence of an interim license, doesn't seem very persuasive. So you seem to have to go beyond that, and then you do go beyond that, and you say, well, we're happy with the ITC approach. But you do have to go beyond, don't you, just asking whether there is a legal process somewhere in the world that is open to you.
Yes, I think it has to be a proper legal process. What one does have to, I do go further because I do obviously say that the ITC affords sufficient protection to Lenovo in considering its FRAND arguments. But to be...
Do you accept the ITC's approach as essentially being the same as the German courts? Namely, what they do is they ask whether your offer is obviously unFRAND. I appreciate that's not the terminology that's used, but that's the substance of it, isn't it?
I don't accept that. No, I mean my position is that what the OUII did is to consider whether it was within the FRAND range, and they found that the offer was well within the FRAND range. So that's my answer on that. But to come back to the legitimate advantages, if I may, of the ITC proceedings, they include. Firstly, that yes, there is commercial leverage, but there's nothing, as I say, wrong with that. Secondly, that they are the body that is going to pronounce most imminently in a way that may ultimately commercially settle this dispute. Because what we know about
that means speed is of the essence.
speed is relevant to us, particularly given the number of years we've been waiting.
I quite understand your complaint. You've been waiting 16 years. That's a point I made earlier. Absolutely. But of course, under our law, you're going to get payment from day one, and you're going to get realistic interest.
I stand by that any commercial organisation that's
Commercial organisation has to be paid sooner rather than later. Yes.
yes, paid in a way that it can.
You want cash in your account, don't you? But at the moment, you stand here refusing an offer of cash in your account.
Well, if I can come back to
This
that.
way to get cash in your account is to accept the interim license.
Well,
and yet you don't want that.
Well,
Speed isn't everything, is it?
Well, I can come back to that point, and if I may, I will. So that I don't forget my answer to the previous question.
I'm sorry, I should let you develop your solutions.
No. I mean, it's extremely helpful to understand where the court is coming from. But in relation to the previous points, in my submission, it is legitimate, a perfectly fair consideration for Ericsson that the body that is due to speak first, potentially in a way that is determinative of a commercial dispute, is the ITC. Because what we know about both the EDNC is that that's going slower than we had hoped, and there's not going to be a hearing before the end of 2026. And we now know from the case that's been developed by Lenovo in the English proceedings that the English court isn't going to make a determination about Fran for many years, because they say, oh, but it's all connected to the 2011 licence. And the 2011 licence, whilst there's been a preliminary issue, that there is no listing even for a hearing of that matter. So we are years away, both in front of the EDNC and the English courts.
Because if Mr. Justice Meads decides that the scope as determined is as argued for by Lenovo, that would be the end of it. So the delay only arises if you're right as to the interpretation of the 2011 licence. And even then, I mean, that's going to be a fairly short point. I mean, the Patents Court doesn't wait years for an issue like that.
Well, I'm afraid we don't agree with what Mr. Lycodopoulos said on that. Lenovo's case is it's not just a matter of the number of units that one tots up. Lenovo's case is that the 5G rate is integrally bound up with its 2011 license point. So it doesn't just affect the number of units that are licensed. It goes to the determination of the FRAND rate. So it's far, and that's not going to be determined by Mr. Justice Mead one way or the other. So it is.
But it will ought to be considered in the April FRAND trial.
No, it won't, my lord. My instructions. I'm afraid I'm not in that hearing, and I'll obviously give you the references. But my understanding, and I can come back on this, is that will not be determined in the April FRAND trial. So we're not going to know the FRAND rate.
Yeah, but can I just understand that everyone agrees that the 2011 dispute has to be determined in this court?
No. No, that was what Mr. Lockwood,
well,
my learned friend, told you, that we do not agree that.
But there is an exclusive jurisdiction clause. So
yes.
How do you get out from under that?
Well, the 2011 licence issues were brought forward by Lenovo itself in front of the ITC and have been grappled with by the ITC. You'll see, certainly by the OUII. What you'll not see the OUI doing is recording a submission. You shouldn't even, just stop. You can't go here because there's an exclusive jurisdiction clause. What you see, and I can come back to this, is the OUII grappling with the issues substantively that arise under the 2011 licence.
But they can't determine the issues substantively, can they?
Well,
I mean, they're not even a court.
Well, whether they can or they can't will be a question in my submission, of the application of United States private international law to the question of
Are you really going to submit that the US wouldn't respect an exclusive jurisdiction clause? Isn't it more that the concern that the whole thing falls away if the ITC determines as you would wish?
My submission is that Lenovo itself has submitted to the jurisdiction of the ITC, and it has decided to advance substantive arguments about the 2011 licence, which the ITC may well determine. There is then a question of private international law from the point of view of the United States about whether that is a legitimate thing for it to do. We have no evidence on that, and I can't possibly say what the outcome of that would be. But what we do know is the point is being argued about substantively. It is not the case that Lenovo has come along and said, can't touch this, exclusive jurisdiction, so I'm afraid down tools. That isn't what is happening. So that in my submission, it's simply not accepted that the only place that could ever happen is here. In my submission, it's happening. It's being considered in other proceedings right now. I still don't think I've answered the question from my law, but maybe I should.
Maybe we should come back at
and-
2:10
and answer that question later.
2:10.
What rights are taken?